call criminal justice, public safety to order at 11 minutes after 11. First order of business is to accept minutes. Thank you, Supervisor Simpson. A second for the minutes. Supervisor Wild, all those in favor?
Aye.
Opposed? Motion carries. Okay, a little switch up on the schedule here because Amy has to sit in for Brian, who's not able to make it today, so bringing her up so she can get off to a training. Amy, you have the floor.
Thank you. I got one. So first thing on our agenda is a resolution request to redo the contract that we have with USGS for the river gauge that's on the Spoon River. We pay for a portion of that, and this is a 3-year contract, and it changes a little bit every single year. It goes up a little bit, about 3%.
Moved by Supervisor Simpson. Is there a second? Supervisor Hogan. Discussion? No discussion. Call the question. All those in favor?
Aye.
Opposed? Motion carries.
Thank you. The only other thing really on the agenda is the fact that Brian and I have had training a little bit over the course of the summer out in Oriskany. He's doing a lot of communication training and stuff. There's been some huge changes to IPS and NIM. Quite a few of you have taken that training, and because of the huge changes, Brian and I have both had to take updates for almost all of our training, so we've gotten all that accomplished over the course of the summer because of it.
Okay. You're feeling pretty up to date on everything?
Yeah.
And the county plays a big role statewide, don't they, in all these trainings and stuff?
We do. Because of the seniority and the experience that both Brian and I have, we are very often requested to either participate in pilot projects that the state has, or we have been requested to teach. And that's one of the things I'm doing this afternoon, is I'm actually teaching them.
Thank you. It's good to be in the lead. Privilege of the floor. Any comments from the committee or from the floor? Okay. Hearing none, we can adjourn your portion. Thank you, Amy.
Thank you, and thank you for letting me go first. I appreciate it, guys.
That's right. Signed council?
Yes.
Okay, I'd like to bring Joy up with a signed council on, I know it...
Reading tiny letters.
Oh, I know it.
I don't know.
We're running out of room. This is a busy schedule here. Joy, you have the floor.
Good morning.
Morning.
We're looking for a resolution to amend the budget. We have another one.
There's Don.
To amend the budget to allow for funds to come from oil, which is going to pay for a new database.
Okay, by Supervisor Garrity, second by Supervisor Sokol. Discussion. And this was an expected revenue?
Correct.
No discussion, call the question. All those in favor?
Aye.
Opposed? None. Motion carries.
Also looking for a resolution to authorize oil distribution to Legal Aid Society, $45,000, which is fully grant funded. And budget.
Supervisor Garrity, Supervisor Sokol on the second. And they're one of your vendors, Legal Aid Society,
Yep.
on this, and that's it's a reimbursement, so it's an up to $45,000, or they? Yes.
Yep, through the grant.
Okay. Any other questions? All those in favor?
Aye.
Opposed? Motion carries.
Last one is a resolution to authorize the agreement with General Code, the purchase of content management system Laserfish Savante, which will replace my current database, and will have billing, which will be used by all the courts and all the attorneys on the list.
Somebody to bring that to the floor? Supervisor Wild, is there a second? Supervisor Merlino, discussion. And, a couple questions. So this is a brand new data management.
Brand new.
We have one currently, a data management?
We have an in-house made one that
Okay.
I've been using. It's actually been there since the 80s.
And it looks like this ties together three aspects of your office?
Correct.
Okay.
And will bring us up to speed on everything that Wells is expecting us to be.
Okay. And we're looking at $42,000?
Correct.
And that was budgeted for this year?
No, we couldn't budget for it because we didn't know if we were actually going to get it. We're still waiting on some of the money. Part of it's Sorrel Herring, Distribution 7. Tammy can answer most of those questions.
Okay,
Better
so
than put them
revenue's
in.
coming in for this?
I'm sorry?
The revenue's coming in for this?
From distributions, that what we're gonna do is we received, authorization to utilize distribution 7, which is, we have the assigned work plan in, distribution 7, and then we had gotten approval to use Sorrel Herring monies from the 5-year plan to offset the assigned work account.
We have an executed contract already from the state for the Distribution 7 revenue. We're waiting on one for the Sorrel Herring revenue. But I just want the committee to be aware that we're going to be looking to put the PO in for this system very quickly after the board meeting so that we're up and running in time for next year.
Thank you. Any further questions?
Oh, one more comment. This Laserfiche Avante will be accessible to the entire county. You just build pods onto it, and it's an incredible management system. So I think everybody should take a look at it.
So this can be used by public
This can be
defender
used by
and...
any entity in the county, any office.
Okay.
Mr.
Supervisor
Chairman,
Wild?
thank you. I appreciate it. Just a quick question. So if we're taking money that's from a Distribution 7, was that earmarked for something else that we're not doing because of this?
Okay, yes it was. The way oils work is most of the oils grants are 3-year grants, and this specific grant, Distribution 7, started back in 2017, but because we didn't have a contract in hand, we didn't hire the folks that were part of that contract, part of that distribution. So, I mean, it worked out well in this situation because we're able to use that funding through that distribution to cover the cost of this product. But it's these distributions, and we'll have 3 distributions active at a given time because they're 3-year grants that stack on themselves. We'll be able to, through the extension of this grant, be able to cover the annual maintenance fees going forward for the software product as well.
And just to follow up, I'm not sure I totally understand, but there was something else that this was earmarked for that we're not doing because we don't need to because it was 2017, or?
Right, because
Yes,
that,
okay.
we never hired those folks because it goes back to 2017.
Okay.
So the money was sitting there in the past, we left the money on the table, we're going to attempt not to do that.
In this case, it's not a bad thing.
This is really an issue with the state not understanding the rules that counties abide by. We don't like to amend our budget until we have an executed agreement in case that funding never comes in. These grants, and the state is getting better, the Office for Indigent Legal Services, but it has a history of taking years to get an executed agreement. So what happens in the meantime is when we had a plan to do a contract in 2017, we just amended the budget today. Obviously, we didn't do any of the work in 2017. So we're trying not to, as Tammy said, leave money on the table by repurposing this. And in the event that we repurpose a portion of this funding for the system that we're approving now, we will get an amended work plan for that grant from the state, and then we'll put in for the reimbursement, which is actually a simple process. The hard part is getting the contract signed.
Amending the... Okay, good. Any further questions on this motion on the table? Hearing none, call the question. All those in favor?
Aye.
Opposed? None. Motion carries.
Thank you.
Thanks. Anybody else you need to bring up at this time? Okay. Jason, you have the floor.
Thank you. I've got a number of items, and some of them are just talking points, and I learned before coming up here that Bob Yusi of Probation is also going to be covering some of this, so I'll try to shorten up my part on bail reform. So as I think most people are aware, there's been a pretty massive criminal justice reform that took place this spring. New laws were signed in, I believe, in April, that will pretty radically alter the way the criminal justice system operates starting January 1, so 5 months from now. That's going to impact probation department, I believe, public defender's office, obviously DA's office, and sheriff, state police, and other law enforcement agencies. I've gotten a lot of individual questions, so I thought it might be valuable to come here and just talk a little bit about it. The two major items of change are bail reform and discovery reform. So bail reform, I'm going to, in both these topics, I'm not going to try to give you a full legal education on these two things, but I'll answer any questions I can, and I'll stay through Bob's in case something comes up after. Typically now in bail, a judge has the authority to set bail on a criminal matter, and they can look at a group of factors to make a determination. They might say, I'll give you an example. Two people are charged with petty larceny. One lives in Queensbury, they stole $50 from Walmart. The other lives in Newark, New Jersey. They also took $50 from Walmart. The one from New Jersey also has a prior criminal history and a history of not appearing in court. So the judge can look at those two and make a decision on bail. What we see almost all the time are three forms. Bail, which is, say the judge said, I'm setting bail of $1,000. You would post that to be released. A bond, which is a secured bond, which says, I'm setting a bond of $1,000. You get a bail bondsman, and you would do, in that case, it might cost you $100 to get released. Or what's ROR, release on recognizance. That's pretty much what you'll see in criminal justice. And ROR just means you're released on your own recognizance. We also do see some, mostly on the felony level, something called release under supervision, where the judge will set up some criteria for the individual to follow if they're released, and that's supervised by the probation department. And I feel like over the years, what I've seen is probation has gotten more of those to deal with. That's the now. Come 2020, all that's going to change. According to things I've read that have been issued by the governor's office, they expect 90% of people that are arrested will not be held pending their case. So you're going to see an initial decrease in jail populations. The court's authority to set bail is being removed in most cases. So in the example I gave with the two petty larcenies, the court would not be permitted to set bail in either of those cases. And it wouldn't matter if the person had a history of not appearing, and it wouldn't matter if the person wasn't from this state. The court cannot set bail in those cases. That carries on into a lot of other cases. So, and I'm going to oversimplify this, but basically the state has said, come 2020, qualified offenses are offenses in which bail can be set. If it's not a qualified offense, in the first instance, the court doesn't have authority to set bail. Qualified offenses are violent felony offenses, so kind of the obvious, murder, rape, and then some that maybe aren't as obvious, burglary. So burglary takes many forms. One form of burglary in the second degree is a violent offense, and it's if someone enters a dwelling. So someplace where we live, someone enters, that's burglary. That particular violent felony offense is an exclusion, so bail can't be set on that either. I think a lot of people that I talk to think of violence when they're, and that's not necessarily a violent felony offense, doesn't always include a violent act, and things that you might consider a violent act aren't designated violent felony offenses. Bail can also be set on sex offenses, and then there's a bunch of little incest, luring of a child. There's a list of items, some of the lesser things that we see. To cite examples of where things will look a lot different. Take burglary in the second degree. I'm here right now, my wife's home, someone breaks into the house, she flees the house, calls the police, they're able to capture that person. That person wrestles with the police, they secure that person, they find out that they're a prior felon and they're from Maryland. The judge will no longer have the authority to set bail on that case. That person will be released in a non-bail fashion. That's a pretty radical change from where we are today. The prosecution can't even argue. We can't say, well, judge, look, they're not from around here. They could get up to 15 years in prison. This is a serious offense. So those go away. And the other, where I think example that comes to mind is, over the years, we've had numerous manslaughter cases where someone's, say, under the influence and they drive drunk in a vehicle and kill someone. And let's say you had a case where that happened and they weren't from around, they were visiting from California, wherever. They're not from around here. They have some prior history out of state. That's not a violent felony offense, therefore that is not bail cannot be set in those cases. Even if they confess and they say, I did it, the judge would not have authority to set bail in those circumstances. So you're going to see a very different landscape in what's going on with cases. Many cases where people would be arraigned, they won't be arraignments. There's going to be what's called appearance tickets, or they call them desk appearance tickets. So you'll be given a ticket. You are to go to court at a later date. And instead of getting in the minutia, I'm giving you the sort of the general terms. So you can see, obviously, a lot fewer people will be on initial cases in custody. And then they have a lot of new rules that permit bail review, the least restrictive bail. Within that bail reform, there's also something that's going to change the way an individual is notified of court. So if someone's given an appearance ticket, you're to come to court. There's now, the Office of Court Administration is tasked with setting up a county agency which will assist the courts in notification processes for all appearances for all defendants. So we had, I think, roughly 1,800 criminal arrests last year. So that's just the felony misdemeanor level, not violation or traffic. So in every one of those cases, for every single appearance, a notification has to be done at the defendant's choosing, either text message, email, or I believe first-class mail. Bob will fill you in. As far as I know, the Office of Court Administration has not designated an agency at this point. If I were to guess, I would look over to Bob and guess that's where it's going to go, and that's going to be a big task for them to take on. The warrants, if someone doesn't appear in court, so we give you the example of that burglary, and we show up in court, they don't appear, the court cannot immediately issue a warrant. With some exceptions, they have to take a 48 hours to attempt to have an agency contact the defense attorney and the person accused and give them an opportunity to come in before a warrant can be issued. So that'll be another, I think, something that will fall to whatever OCA deems the agency that's going to do it. So you can see that's a pretty, I would say, radical change to the process. Where I think that's going to impact things, I think it's going to impact things for the sheriff's office. I think it's going to impact the DA's office, victim services, possibly defense counsel, because they may have trouble contacting clients, and certainly probation, because I'm foreseeing this. I say victims and DA's office because, in my experience, and taking that example where a family member's been killed by, say, a drunk driver, victims want answers, and they have expectations from, the past 50 years of how things work. It's different now. So we're going to be doing a lot of explaining and trying to make them understand that the law doesn't allow bail, that the person is going to be free during the pendency of this case. And that causes stresses and other issues for victims. Obviously, there's all different kinds of victims, domestic violence. So I feel that's going to have a big impact on victim advocates, the DA's office. And then, of course, I don't want to predict, but I would assume if you have more people released, a percentage of people don't come to court, and warrants do happen, I would assume that the number will go up because more people will be released. Even if the percentage remains the same, you're going to have more. That means that we have to seek warrants, police have to try to find them. If they're out of state, there is a cost to the county to get people here. We just got someone for California. We had to send 2 officers to get hotel rooms. I think it's $3,500. About a third of our budget for extradition. That was for one felon that we were able to get. That's a very rare case where we think we have a shot at recouping money because the person had federal charges. So we're hoping we're going to be able to recoup it from a federal agency, which I don't know if I've ever seen that happen, but we think that's going to happen. So that's a big, quick version of bail reform. And like I said, Bob's speaking on that as well. Discovery reform is pretty massive. Some say it's bigger than the bail reform. So when I talk about discovery, what discovery is, what they call discovery, has changed. It's not going to be what it was before. It's a way larger context, and the timing of disclosure is changing pretty radically. So in the current system, I like the petty larceny example when I'm looking to Marcy. Marcy and I might show up at the centralized arraignment part, and I'm given a few pieces of paper from an officer. It says petty larceny, $50 Walmart. There's some information. And I turn to Marcy and I say, what do you think about an ACOD, adjourn this case in contemplation dismissal with some community service? And she might talk to her client who's already confessed it to the Walmart people. And they say yes. And that case resolves in that moment. That happens on all levels of criminal justice, not just the petty larceny. Maybe not in the moment, but a quick conference and you're able to resolve things. Under the new rules, discovery must be turned over within 15 days of arraignment on all criminal cases. So if a felony is arraigned in a local court, whether it's a murder, a rape, a grand larceny, the manslaughter I'm talking about, all discovery must be disclosed within the 15 days. And it's not the old discovery that we have now, it's new discovery. So the old discovery would be a list. They enumerate a list of items to be turned over, photographs, videos, certain items. The new list includes all the old, and then it adds something called Rosario. Rosario is normally disclosed at hearings and at trials, and materials that we don't normally have. We're expected to have a witness list ready to be turned over within the first 15 days. That witness list is expected to have contact information for all of those individuals in the first 15 days. If there was a 911 recording, that is to be disclosed in 15. If there is, and Sean Lamry has discussed that with me quite a bit, if there's a recorded phone call, even though it wasn't a 911 call, that's been recorded with the sheriffs, the new law says that the DA's office knows about all the information that any police agency holds. And we're presumed to have knowledge of what's in their files, and we're responsible for turning it all over. On a practical level, I can tell you I don't know what's in every single file of every police officer in the state of New York. I don't think anybody does. That's what it says. Currently, we can announce we're ready for trial in a case in first review of a file. That's no longer the case. In the new version, until all this disclosure's been made, we're not ready. And we can't say we're ready, so a clock is ticking against that file, potentially. And these clocks are quick. On a B misdemeanor, it's 60 days. On an A misdemeanor, it's 90 days. On a felony, including murder, rape, whatever, it's 6 months. So this is obviously creating a massive burden on law enforcement agencies, including the DA's office, to try to figure out how are we going to accomplish this. We don't do discovery on every case now because you don't need to, because resolutions sometimes are quick and easy, just because of practical people working in the system, coming to practical resolutions. I don't see that remaining the same. We don't always do the Rosario disclosures because oftentimes we reach resolutions after the current form of discovery occurs. Current discovery is never done in a 15-day window because we often don't have files in 15 days. And that would be, we might get a partial file, but the new kind of discovery and the new file we're presumed to have, we don't have. So where does this impact things? Obviously in my office it's having already a pretty profound impact. We're meeting weekly discussing how are we possibly going to do this? How can we get this? I've been meeting with members of law enforcement to say, how can you get us all of this information? And we're trying to figure out how can we get it all and then organize it, because it must be organized in a way so that we can certify under oath on all 1,800 criminal cases that we're turning it all over to the defense. I don't want to underplay how big this is. This is a massive change in what's going on currently. We are trying right now to get ourselves into a position where we can do it. You can't turn a switch on in 2020. No one gave me a switch to click at 2020, and this just happens automatically. We've been working on it since the new laws passed. We are attempting right now, and I had already started slowly, and now we're trying to accelerate getting material digitally so that we can turn it over digitally. I know Marcy's no longer on the case, but Marcy had a pretty big case that I was able to do a digital partial disclosure to her. It would have never complied with the new rules in 2020, but it was something. And I think that worked. So we are, as of last week, just starting to roll out with a couple of the smaller courts and attempting to try, I'm going to call it a hybrid. We're not meeting the 2020 standards, but we're going above and beyond 2019 in an effort to see what is it going to take to make this happen. So that's discovery reform, and I feel I'm probably missing a lot of the aspects of it. You could go on and talk about what is discovery. What am I talking about with that? It's basically anything that's considered relevant to a file. By the way, we have 50 years of jurisprudence under the current rules, so courts have looked at things and made rulings and decisions and helped guide us and say this is the rule. That's going to have to start over because there's new kinds of hearings, there's new kinds of rules that are being put in play. We don't know what's going to happen and how those things are going to be implemented. But that is a real quick, I think, nutshell version of what's going on.
Questions, Supervisor Wild?
Mr. Chairman, thank you. Jason, thanks. I'm going to assume, based on your presentation, that you're not the only district attorney that has an issue with this across the state.
Every single DA.
So are there any chance of any modification of this legislation happening between now and January 1?
So what we're being told, so I'm a member of the District Attorneys Association for the state, and I went to a meeting in July, earlier this month, to have those discussions. And I don't want to be colorful, but everyone's concerned. I'm not even touching on things like traffic matters. We handle about 20,000 traffic matters a year in our office, or the county gets about 20,000. We handle a percentage of those. There may be some major changes that are going to impact those. If that happens, that's going to be impacting revenues to the town. I don't even have really the opportunity to figure that out yet. I'm focused on our criminal matters first. What I'm being told is there is not a likely change to any of this, and that this is happening 2020. That maybe there will be some changes after we get going and things start to unfurl. But I'm being told don't expect any changes to what's currently in place. And I will mention these decisions were made in the budget process. I did include 3 articles for you to consider. One's the New York Association of Counties, which recognizes this is going to increase costs for probation, DA's offices, and police. There's a New York Law Journal that talks about what's going on, and then there's the Manhattan DA. It was in the New York Post, an article from some DAs in larger counties talking about what they foresee their increased costs are going to be in relation to these new mandates that have been placed upon their departments. So, I don't know.
Thanks, Jason.
Any other questions?
Any other questions? Hearing none, go on.
So the second item really is just, I'm going to call it a piece of news. We have, as I think many of you are aware, a crime victim program. Crime victim advocates service our crime victims and attempt to help them with restitution, navigating criminal justice. We've got some really experienced people, and in the last couple of years, we were able to get a third part-time position filled. We've been in the grant application process for some time, and we recently received our grant award, which is a terrific thing. The Office of Victim Services has given an award. When they give those awards, they put a caveat that it's subject to contractual rights and it's subject to the finances being there. Our award for the next 3 years is approximately $452,000. This is a matching grant, so they give 80%, the county does 20%. The numbers sound great. They aren't great, honestly. I contacted Office of Victim Services, and what they've indicated is this grant cycle, they had a lot more players that came in seeking monies, and they've cut across the board. All existing programs have received a cut so that they could give to these other victim services throughout the state. The monies that they did give us will not support the staff that we have right now. I've spoken to our part-time person and indicated that, barring some change, that our last day will be September 30th because our grant runs till September 30th, and then we enter this new grant period. So we do have enough under the old, we do not have enough under the new. It not only will impact that individual, I'm presuming I'll be talking about this in budget, but if there's a financial match of the 20%, we could cover the 2 full-times. Without that, we're going to have a shortfall as well. In the past, we've been able to do this almost exclusively on the grant funding because the county provides the space for the program to run, and we've had a really robust internship program that is an allowable matching item. If we were to continue in that way, we would not be able to continue with even the 2 full-time. We would not have enough to meet that.
Supervisor Driscoll.
Thank you, Mr. Chairman. Jason, in the past, have you been able to share personnel with other organizations that receive that money within the region, or?
In the past, the way our program works is we have our internal people. They work with other agencies a lot, but I don't have, for example, Manoa Avenito's here. I don't send her off to work she's got enough work just to meet her duties here.
Sure.
So they don't leave and do other work. But where you'll see it sometimes is if you have a victim need, for example, we recently had a very serious violent crime. I reached out to Minot, and ultimately one of our assistants came and spent the evening with the victim at the police station. We were just in the very initial stages of that process, and so I was working on other things, and we needed a victim advocate there, so we had a victim advocate present. So that would be not in our office, but it's the big picture. And sometimes our victim advocates are working with individuals when law enforcement brings something that doesn't ultimately lead to a necessarily criminal prosecution, but they're involved in that. So I don't know if that's answering your question.
Yeah. Right, yeah,
We
yeah.
do, respecting all victims, so we do longer term treatment, counseling, follow-up, services that we can provide directly, housing, things like that, so they can get property.
Great, okay, thank you.
Any questions on that? The third thing, in anticipation of all these, in preparation really for all these new laws to come in, I've had to change the way that we're running the office right now, just to see what we are able to pump out as far as meeting these obligations. And where that's it's falling on the staff, it's falling on the attorneys. Our goal is to switch to a more digital process so that we can receive information digitally, we can file it digitally, and we can transmit it in that fashion. We're certainly not in any shape to do it now, but we're trying it on a small scale. Every one of our staff people is now being asked to learn this new process. I have 4 people with 4 different current titles: a clerk, a keyboard specialist, a word processing specialist, and a secretary. They're all doing the same work. Since April came out, I've been training them on a new process. We're still training. They're not. I'm asking them for feedback too. How do we do this? What's going to be the fastest, most efficient way to make this happen? So I have put a lot of extra work on them. They're now having to learn sort of a digital system that we're using through the New York Prosecutor Training Institute within our own system, so that we can reach out to law enforcement and ask them to upload information, and then we have to figure out a way to file it properly for our disclosures. That is going on a small scale right now, and the truthful nature of what I'm asking for is I'm asking to have these individuals, these positions classified as legal clerks. It's at 5. I talked to HR and specifically civil service. They said, I've got these people working out of class, and the legal clerk is the appropriate classification. So that is my plan. I need them, and I basically brought them all in, and they're really good workers and good people. And I said, we don't have a choice. This has to be done. We can't wait till 2020 and hope we figure it out on the first day, or cases will get dismissed, and victims will suffer, public safety will suffer. So that is my current plan. I don't know that we can do it with what we have, but we're going to try to do it right now and find out what we can find out. So my first request, now making request, is to create 4 legal clerk positions, delete a secretary 1, and defund the others. I'll make that motion.
Okay, moved by Supervisor Garrity, second by Supervisor Driscoll. Discussion on this. Just one clarification, the difference between deleting and defunding.
So deleting means that position just doesn't exist anymore. The defunding means that the position is still there, but it couldn't be filled without, well, it can be filled anyway without coming here, but it would have to get request for funding to make that happen. So those positions, I guess, just exist somewhere in the netherworld.
And the reason for doing this is the 4 employees that we're talking about, who have all been trained, who are good employees, who Jason would like to see continue in the office. One of them does not have permanent status, civil service-wise, in an existing position. That's the position that we'll eliminate. The other 3 do have status. So eventually these legal clerks are going to be tested. in the event that an experienced employee doesn't pass that test, rather than just have that be the end of it and we have no choice but to let them go. We just want to keep an option open for them to be able to stay in the office. So that's why we'll have those 3 positions technically still alive but not funded, and hopefully we'll abolish those when the test is done and everybody passes.
We have a motion on the floor. Yes.
Yeah, just one more question, Mr. Chairman. Are these funds in your budget? I'm assuming it's an upgrade.
It is, and that's the 4th part, the request to fill. I think that falls under 4.
Okay, yep.
So I put to be determined the amount to get us to the end of the year from, I think, September 1. I think from HR, I think it's $2,712.01 for the 4, and that would include salary and fringe differentials. What I don't know is whether it's in there. And the reason I say that is we had an attorney, I don't know if you recall, in the winter, at the beginning of the year, who left. We had a gap as we were interviewing and trying to fill that for several months. So, in my mind, potentially, that gap could cover this for the year. But I'm not really good on that side of things.
No further discussion. We'll call the Supervisor Garrity.
Make it 3 and 4.
Okay, and who seconded that motion?
I did.
Yes.
Yeah.
You fine with that
Yep.
amendment for number 3 and 4? That's before the committee at this time to vote on. All those in favor?
Aye.
Opposed? Motion carries.
Thank you. I'll stick around just in case.
Okay. Thank you, DA. Next up is Sheriff Office. Under Sheriff Flammery, you have the floor.
Good morning. We have a very short agenda for today. Under our action agenda, item A is request a resolution to amend the county budget to have the Luzerne Central School District. This reflects our expenditures for this calendar year and the revenues to replace those expenditures. I'm all with it.
Okay, Supervisor Garrity on the motion, Supervisor Sokol on the second. So, all those, any discussion? All those in favor?
Aye.
Opposed? Motion carries.
Item B is request a resolution to transfer funds for New York State grants. We were advised by Rob Lynch that the codes that these grants sat in were set for federal grants, when in fact they're state grants, so it's more of a clerical thing. I'm with it.
Okay, Supervisor Garrity, Supervisor Molino on the second. Discussion? All those in favor?
Aye.
Opposed? Motion carries.
Item C is request a resolution to authorize the chairman of the Warren County Board of Supervisors to sign the 2020 Police Traffic Services Grant. This is a change from what the New York State Governor's Traffic Safety Committee has done in any of the previous years. Now they're actually sending written contracts for some of the larger grants.
Okay, Supervisor Sokol, Supervisor Simpson on the second. Discussion? All those in favor?
Aye.
Opposed? Motion carries.
Under topics for discussion, item A, we currently have 5 vacancies for correction officers, and again, our correction administration is looking to fill those positions. I just want to touch on the bail reform and the laws and
Thank you.
basically what we expect and how they're going to impact the operations of the sheriff's office. I had read a report from our partners in Washington County where they have a 189-bed correctional facility, and they anticipate having 35 in custody once this bail reform kicks in. As of today, we have 98 people in custody. To put that in some sort of a comparison, about a year ago, we were up in the 170s. Bail reform hasn't kicked in yet, so that has nothing to do with why our population has actually decreased. We do anticipate that our population is going to plunge as well once this kicks in. We'll have to work with the state to figure out how we can address that. Maybe we can make some changes in the operations over there. It might be a cost savings to the county.
Supervisor Garrity.
Yeah, that's my question is, has anybody in corrections
thought about this at all, about how they would, because before, the positions were always mandated, even if you didn't need it, you still had to have it filled. Is there any discussions about what they're going to do?
I believe we would have to reach out to the New York State Commission of Corrections.
They haven't.
I don't believe we've done that yet, and speaking openly about this, is that we probably have to look at perhaps closing some of the pods.
Right.
And then having a new staffing analysis done, and say, this is how many posts you have there, not utilizing the space in the facility anymore.
Because the regulations don't allow you to do certain things.
Right now, we're locked into what the New York State Commission of Corrections said we have to have proposed.
Another well-thought-out plan by Albany.
And then, Under Sheriff Lemmer, in predicting for the budgets then, how are you going to start? With a conservative drop or with more?
So I do know that the sheriff and I had recently got pricing for the medical services that we contract for now. And we know that pricing is going to go down because we're basing it on a much lower population. If you recall, when we did the budget for this year, our population's the highest we've ever seen. So we upped the average number for contract purposes. Well, now we're going to go right back in the opposite direction, even lower than what we historically have had. So this would be a savings there. When you look at the supplies, you look at the what we budget for food for the facility, all those numbers were bumped up for this year, and obviously we'll have to reduce those for next year.
Okay, yeah. Brian?
Not to speak out of turn with the budget officer here, but I would expect it'll take a little bit of time to see where our population settles once these reforms go in. I would suspect, at least in the beginning, that the salary budget wouldn't change, but perhaps the overtime will go down as we can potentially shift inmates as permissible around pods. When we have overtime, it's in order to meet minimum staffing to cover pods. So if a pod is empty, we may have some administrative flexibility until we get a new staffing analysis approved by the state, not to fill those slots on overtime. So that's where I would expect initial personnel savings for next year.
Thank you. Supervisor McDivitt.
Would it be unreasonable at this point to take a preemptive approach and to invite the state of New York to come before us and to kind of give us a perspective in terms of what our manpower needs will be going in the future? I know I sat on the board when I listened to the presentation from the officials from the state. Strongly suggested that overtime would go down at the jail. Also, overtime requested, I think, 12 to 15 additional correctional officers. So my point is there anything wrong with, again, taking a step forward, bring these folks, invite them to our facility to kind of get a perspective for them so that we're ahead of the curve. We're going to lower our jail population by significant numbers. It would just seem to follow that you would need less human beings to take care of the facility. So again, an invite to the people that are actually making the rules in the state of New York to give us a perspective on what kind of a future we face in terms of controlling costs at correctional facilities all over the state of New York.
Okay. Sean, any response to that request there? You think that's doable? Who would we ask?
If that's the will of the committee, we certainly make that contact with them and reach out to them.
So, committee? Nod? Would we like to get more information on this from the state? Bring them forward to think it through a little bit more there? Supervisor Simpson?
Yeah, I mean, we could have them here, but I just wonder, what numbers do we tell them? What do we base it on? What do they base their judgment on? I mean, I don't know if anybody's going to be able to predict this at this point, so I don't know.
Supervisor
They are
Garrett?
the rule makers, so they should tell us what kind of rules they're going to change. They make the rules, the states, they should be working on this. I don't think
calling them in would be all right if we knew the population is going to be this or that. But they make the rules, so let them, somebody can contact and say, tell us what the rule change is going to be.
I think part of Supervisor McDivitt's thinking is that this is a forum for the county to advocate for answers on this that would fit us.
I sat during their presentation, and I think they tend to have a tendency to lean in a certain direction. That's my own personal evaluation, but it's just, these people make the rules. Write them in, give us a perspective. If we close one pod, what does it mean? If we close two pods, what does it mean? I mean, if we have an adjoining county, if we have the state of New York, where each county in the state of New York is mandated by state law that you will in fact have your own unique corrections. Over time, we find our population dramatically going down. I mean, why not get ahead of the curve? Why not get the professionals to come in and say, okay, if this indeed happens in Warren County, and this indeed happens in Washington County, this is what I would anticipate occurring within your facility. You probably should close this pod or that pod. You probably will result in a dozen less employees, thereby reducing costs. So it's just, let's beat the other counties to the punch and kind of get some expert guidance.
John, can you put an ask out there?
Absolutely.
Thank you.
Thank you. Appreciate it.
The other thing I want to touch on is under the disclosure changes, we had the opportunity to sit down with Jason and his staff about a month or so ago to discuss some of the changes and how they're actually going to impact law enforcement. We have another meeting this Wednesday afternoon, and working out some of the logistics. And just to give you an idea, it's not uncommon for us now to provide 911 calls for criminal cases that are headed off to trial. It's not uncommon to provide what we call radio logs, which is a written log, typed log in the computer of every radio transmission. So you can see what's going on. As I understand the changes as we move forward, that's not going to be acceptable anymore. We're going to have to provide every radio transmission, every law enforcement transmission. If there's EMS called to the scene, if there's fire called to the scene, these are all things that we're now going to have to provide within that 15 days of arraignment. I know logistically, in speaking with our communications supervisor who oversees the entire 911 center, he feels this could become quite the burden to the point where we may task somebody with doing this on a full-time basis once this actually gets sent. But it doesn't stop there. When somebody is brought into our office, I'm being told that we have to provide every video recording. So video recording at the sheriff's office starts when you start coming onto the property. Everything is captured on cameras. If you move through the hallways, everything is captured. It's brought down in the corrections. It's all captured. And we're being told that most likely we have to provide all this. So this is going to be a burden on our IT people to gather all this information as well. We don't know how this is going to shake out in the end, but it's only aware of some of the impacts that we may see as we move forward.
Right. It's a whole new world. Yeah. Privilege of the floor. Anything for Sheriff Department? Sheriff Office? So. Supervisor Wild?
Chairman, I'm just curious, Sean, do we have to actually provide those videos, or do you actually, can you provide kind of like a link, so you're not actually preparing a CD or something that you're, or some kind of media, you just provide them a link to this information that might be a little bit simpler?
In the past, we've burned CDs, burned DVDs, and we do the flash drives, information on flash drives. We're going to be doing everything digitally now, almost like if you're familiar with Dropbox, dragging it in, dropping it into a folder. It tracks who put it in the folder, the date, the time. It tracks who opens it up. So there's accountability on all sides of the fence as well.
Thank you.
If I could jump in on this.
Yes, District Attorney.
That new system that we're talking about. And the trouble, though, I think, and John, maybe you're kindly describing it, these files those videos are running 24/7. So if someone walks down the hallway, an inmates walk down the hallway, doesn't have like a special designation, Joe Blow, walk down a hallway. So someone's going to have to find that, parse it out, send it over. It's got to get attached to a file so that it then can go to public defender's office, assigned counsel, and private attorneys. As you can imagine, that creates an incredible burden on folks on all sides of the equation. When he's talking about the 911 reporting center, I think to a layperson, you think a 911 call comes in and say, I'm calling about an incident, and you just pull that call. Well, some people don't call 911, they just call the sheriff's office. That gets reported, even though it's not the same thing. And they don't always have a name attached to it, so someone has to figure out where do those go, what file do they belong to, how do we get that to all the parties, and how do we do it in this really quick turnaround in 15 days. And that as we keep looking, we feel like we're peeling an onion, and when you peel an onion, it makes you cry. And so, we're trying to figure it all out.
Thank you. Anything else for the sheriff's office at this time? No? Thank you, Undersheriff. Probation is next. Director?
Good afternoon. First thing I have on my agenda until I get to bail reform is a resolution request to allow myself to attend a American Probation Parole Conference in San Francisco later in August. There's no cost to the county. All costs will be paid by my Probation Directors Association.
Okay, moved by Supervisor Garrity, second by Supervisor Merlino.
I have one question.
Go ahead.
Are the Yankees on the West Coast?
The Yankees are on the West Coast. They're playing the Oakland A's on Tuesday, August 21st. I will be there. We're hoping they have more pitching by then.
All those in favor?
Aye.
Opposed? Motion carries.
Bail reform. I handed out a pretty in-depth and I think a PowerPoint that explains process and all the nuances to the law, and District Attorney Harrison, I think, explained the gist of bail reform fairly well, so I won't repeat things that are said. I think more what I want to focus on is the implementation. How do we get to where we're going to get when January comes and where we are, and the things that need to be looked at as we go through the next couple of months. As Jason said, bail will be eliminated for misdemeanor and non-violent felonies, and the numbers as described are pretty large. Bail can be set on violent felonies, and I think the interesting thing too with, I don't know if Jason touched upon it before, bail is not an option for Class A drug felons, and we get a lot of drug dealers that come up from the city, have no ties to the area, and those people will be released. So, what does that do? Will they come back, and what does that do to the ability for us to go get them with law enforcement and those kinds of things? Getting people out of metropolitan New York is not easy. So, there's a lot of things that this law does and changes. With respect to implementation, what do we do when this happens on January 1st? Well, I think we first look at is the fact that we do not have any regulations or guidance at this point. As I said earlier when we talked about this in March, I think that the Office of Court Administration is going to be the regulatory agency for bail reform and for pretrial service agencies within counties. This is something that they're not accustomed to doing. Before that, it was regulated by DCJS, so this is new to them. There's a work group made up of OCA personnel, DCJS personnel, the New York State Pretrial Association, their personnel, and a large criminal justice agency, non-for-profit out of the city called Criminal Justice Agency, that are working on developing regulations and guidelines. So they believe they will be out in September. at least the draft portion. So at this point, we have no regulations, we have no guidance, we know just what the law says. And sometimes the regulations and/or guidance is a little bit different than what the law prescribes. So at this point, we're speculating on a lot of things, but until the regulations come out, we won't know what the specifics are. I know that OCA, we met with them and they indicated that they say they won't tell the counties what to do. They won't tell the counties that who your pretrial service agency is. They will allow the counties to choose that agency. I mean, obviously, here in Warren County, we operate a pretrial service agency, so I fully believe, obviously, that will be us, and we've been planning and thinking ahead. So OCA, after the regulations are developed, they're going to send a plan to the county, one, to designate a pretrial service agency. And what they're doing is they're, in conjunction with the Criminal Justice Agency out of New York, they're developing, I guess they would call it a gold standard plan of where they want counties to be with respect to pretrial service agencies. So,
And those service agencies, is that an in-house or is that an outside contractor?
pretrial service agency can be a county agency within the county, or the county can contract with someone.
Okay.
So, assuming that we would be the pretrial service agency within the county would designate us. There would be a plan of where we're at, what services we could provide, and I guess the plan to get forward to respect to what the county, what the state would believe would be your gold standard. And I say that for a couple of reasons. We operate a pretrial service agency. We have a probation assistant that's part of her job that does it. We probably have 65 or 70 people that report to us either by phone or in person. But this law expands it a little bit more. Most of the people that we hope that this bail reform will fall under would be released under recognizance, which have no ties to anybody. The court releases them and the expectation is they appear to court. We don't supervise them. We have no contact with them. When this law goes into effect, what will our courts expect us to do with that population? We do supervise people on RUS where they either call into our department or they're supervised. We assume that population will expand as we go forward. The big things to look at, and the reason I brought up the ROR is, I think a couple concerning components of this law have to do with court notification, where, as Jason said, the courts are responsible for notifying individuals of their next court date, either by phone, email, text, or first-class mail, as preferred by the defendant. The courts could ask for the assistance of pretrial service agencies and the county to assist them with notifications. So for argument's sake, if our courts were asking us to help notify 400 ROR people, that's something we're just simply not set up to do, and that's an unrealistic, I think, assumption that will happen on January 1. So that's something to look at. And the other thing is it also calls for an electronic monitoring component in the new law. We currently do electronic monitoring on ROR cases. The difference now with this law says that a county either has to do it in-house or contract with a non-profit entity to do electronic monitoring.
Which we do now, correct?
We contract with a profit-driven company. There are no non-profit. The intent of the legislation was not to have anybody on electronic monitoring. Either that or you do it in-house. We don't do it in-house here. The cost of that would be, at a very minimum, $25,000 for equipment, and then the cost of manpower to monitor the transactions that happen on electronic monitoring. So a couple of things to keep in mind as we go is rules and regulations should be out in September, or at least in draft form, so we can take a look and see what that is. The county will get notified by OCA of what county agency they want to be pretrial service agency, and what our plan is. What's our plan to comply with the law, comply with the regulations. When we look at those things, I think we have a better idea of what we need to do. A couple things, Jason and I have been speaking, and a couple things we want to do is reach out to the district office of OCA and ask them where they're at and have a conversation with them to talk about how we're going to do this in Warren County. I've spoken to Judge Hobbs, the city court judge, who's also the supervising judge of local courts in this area. We briefly spoke with him about the legislation a couple of weeks ago. So there's more follow-up and contact for that. I think down the road, we probably, after we see the regulations and when we start developing our plan, we probably need to meet with our courts to see what their expectations are come January 1, and then to relay where we're at, what we realistically can do for the courts on January 1. And as we go further into the year, we can build upon what we do when we see what we're looking at. But we're, at this point, projecting things that we don't know. We have an idea of what they will be, but at this point, the regulations are now, and we haven't even designated pretrial services. A couple of things we want to look at. I know what NISAC is doing is they're on a statewide task force with the governor's office that is looking to make the regulations. There is no funding in this current budget for this. Obviously, this is going to cost some money, probably a great deal of money. Our hope come for next year's budget, which starts on April 1st of 2020, would be to put projections in of what this would be, what the cost would be to the county. I talked about us not being in a position to mass notify people of their court dates. We, as well as 57 other counties in the state, have a statewide caseload management system. The vendor is in the process of developing a pretrial services piece to that, which would fit into what our case management services are and would allow us to have the ability to notify people of their court dates. Relatively simple, either via text or email. That costs money to do it statewide. It's $300,000 to include that for every county in the state. That's going to be one of the asks we do. If we did that separately as a standalone county, that's probably at least $5,000 to start the project, or to have it, and then there's different fees every year to license it and going forward. So.
And this is in addition to the software we are currently using already?
Correct.
Okay, thank you.
I believe that DCJS, when they thought that they were going to be the regulatory agency, we worked with the Office of Probation and Correctional Alternatives, which is the office of DCJS. When they thought that they were going to be the regulatory agency, that was going to be one of their asks for Audubon, which is our vendor, to provide that pretrial services component to all the counties to have the ability to notify. So just to conclude, one of the things the NISAC asked OCA to include when they send the county plans out would be the fiscal impact it would have to the county. So when we fill our plan out, we can add figures and dollar figures of what this would cost for us to implement countywide. The cost are not only to my department, as Jason said, there's cost to the district attorney's office, the sheriff's office is involved, public defenders certainly. So with that said, I'd open it up for any questions.
Supervisor Garrity.
Yeah. For the local courts, they're going to have to learn a whole new set of rules. I would assume that's going to impact the town budgets because there won't be any bail taken in anymore. Are they going to, is somebody going to clue us in on how much reduce our town budgets?
Yeah, I mean, that's a good point. I think those are all things that NISAC is looking into. And the other part, talking about local courts, one of our questions to OCA is, when are you going to change, when will the local judges be trained?
Well, that's...
Because the first point of impact is our local magistrates. every year OCA does training for the county judges and Supreme Court judges, but that's further into the system. And the first impact is your local justice who is going to see this individual. They indicated they would look to train them in October. So as you can see, there's a short period of time to implement and for us to prepare for the fall across the board, not only for county agencies, but for local courts and for local towns to figure out what's the impact of them.
Right, because there's going to be a pretty good loss of revenue for a court like ours. We're pretty busy in a lot of them. Hopefully we get some direction before November.
Right, and the fact that OCA, they're talking about September to have regulations, that's probably not going to happen until October, so I think September is the budget.
Supervisor Wild?
Thank you, Mr. Chairman. I'm sensing that there's an awful lot to do here between now and January 1. Is there a chance that you guys can work together to put together like a plan, a coordinated plan between each organization, right? The DA's office, the Sheriff's office, your office, just so we can get a sense of, as time goes by, what our risks are. And I don't even know what our risks are. I know that there's probably going to be an ask for increased funding, but are we going to have a number of cases that might be dismissed because we're falling short on something? So I'd like to get a sense of, we know where we need to be. Just how are we going to get there, and what are the risks as this starts to transpire and gets us closer the next 5 months or so?
Right, certainly we've been speaking with the district attorney's office, we have good relationship with everybody in the sheriff's office. And I think when we see with OCAs, when they send the plan out to the counties, we can certainly have something in writing, but prior to that, we'll have conversations with respect to that.
I'd just like to see that combined sense of risk as we're going forward, and how we're going to address that.
So as far as the risk to a criminal case, so is that if there's non-compliance, evidence can be suppressed, and in some circumstances, the case can be dismissed. So we, as the DA's office and with all the parties, we don't want it to happen for non-compliance. The case goes through criminal justice and someone's acquitted, that's fine, that's the system at work. What we don't want is a scenario where we can't meet the standards that are the new standards, and we're contacting victims with our fewer victim advocates and telling them, sorry, we didn't hit the 15-day mark. The judge precluded that statement, or precluded that piece of evidence that's critical for that case to go forward. So our goal is to meet all those standards. Bob's situation is a little different, and he's got to figure out how am I going to, assuming his agency becomes the one. It won't, but I don't see any other agency floating around. How are we going to notify all of these people, and for every appearance, not like a case goes on a one appearance, one and done, every appearance. So we'd certainly be happy to come back up here and talk about where we're at as things progress. I'm shifting my time into this as much as I can while doing everything else. And I'm sure Bob's putting a lot into it. Everybody that's in these departments, and of course, some of them are county departments. Unfortunately, state police has their own systems. Glens Falls Police Department, they have different computer software than the sheriff uses. Getting it all to mesh and figuring it all out, it's a rush, I think, right now, and everyone's trying to get it done as quick as we can.
And certainly going forward, not only will we talk with the district attorney's office, as I said, we want to meet with OCA, we want to talk to our local courts, we want to see what their thinking is, and hopefully we can meet common ground, at least when January starts, we can say this is what we can offer for you. Maybe that increases as we work towards something, and maybe we get funding. So I think we need to see what everybody's expectations are. And as we do that through the next couple of months, that's something we can certainly report back.
Okay, thank you. Supervisor Hogan, you looked question. A lot of things happen because it's in response to the need or the problem. What was the problem with the previous system?
I will speak about it quickly, and Jason may be offer further things. I believe it's because of what's happening in New York City. I think if you talk to most people, what happens upstate and what happens in our county, I think works. I think with respect to what happens in New York City prompted this. I think the things that have happened on Rikers Island, what people are detained for years without getting a court hearing or a court adjudication, I think prompted this. There's advocacy agencies in the city that push this pretty heavily, vocally, and they're well funded. So I think this is a result of things that have happened in the metropolitan area of New York City that is affecting us statewide.
What do you think the chances are of separating the tail from the dog on this issue here?
Probably none. And I think Supervisor Wild talked about legislation to correct this, and I think when we spoke to OCA, they were brought into the conversation like the day before this law was going to be passed, and they knew that notification and the electronic monitoring would be a problem outside of New York City, and they asked for that to be taken out or amended, and no one listened to them. So if anything could happen, and I agree with Jason, I don't think that they will touch this because this is a new law. I think the best hope would be to push the Office of Court Administration to do a departmental bill to clean up this bill for things that, not to change the intent, but maybe to talk about how we're going to implement it. If possible to implement, then we're not going to, then the law is going to be not good. So, those are some things to look at, but I believe that once January comes and into next year, probably not much of a chance that anybody's going to change this.
Was this bill reform initiative and the discovery something in the works for a period of time and just finally came of age, or did something else happen that?
I can speak to bail reform. I know that the governor put it in his budget last year. There were different, his version was a lot better than this, so it's been talked about for the last couple of years with the discovery. I can't answer that. I would defer to Jason, but I think things have been thought about for the last couple of years that the situation was right to make those things happen right now.
Okay, thank you. Any other questions? Yes, Chairman?
Yeah, I would assume that training would happen to police officers as well. I mean, you don't get a few pages into this and it starts off and appearances taken as to be issued by a police officer, so not just our judges, as Mr. Garrity pointed out, but actually some of us have police departments as well as the county, so I would anticipate there's going to have to be some significant training that's along there at the point of sort of point of contact, so to speak.
Absolutely, and that the first line is the police officer and issuing desk appearance tickets, and the other thing they're required to do is to get contact information out of these individuals when you transmit it to the court. And if an individual court date is more than 72 hours, then the court or with the assistance of the pretrial service agency, you're responsible for notifying these people from the court date. Again, that's something we're not set up to do. Getting information from defendants sometimes be shocking to say that they would give you wrong information, and what happens if we get a wrong address and we're sending letters to somebody that we're not supposed to, or we're getting phone numbers that are incorrect. There's a lot of things that could go wrong, and training, I'm sure, would be provided for all those agencies, and hopefully.
Yeah, I could just envision any kind of woulda, coulda, shoulda scenario that would come out of this, but when you set that training, please remember the bulk which place.
Well, I can speak to that a little bit. So we had, I was invited by the sheriff's office to speak maybe 2 months ago, and they brought in all their members over 2 different periods in which we did initial training, more just explanations of all these new rules and how they're going to apply. That was the first one. It was agreed by all, and we were going to need to do a lot more of that. I haven't done that with each agency. That was the sheriff's. I've met with the chief, head of the police in the American State Police, and we're having conversations individually, and we've offered to, we're going to try to, with the best of our ability, do training with officers as they request. And I'm presuming you're changing a complete institution and how it works. You can't just meet with someone for an hour and say, here's the new rules, you're going to do everything different, good luck, and expect that to happen. So we realize that. And you know, a lot of times you go to a meeting, you have a meeting, and when you leave, you hear some good ideas, you go back and just go back to what you know. So there's going to take quite a bit of effort just to get all those changes to slowly bake into the whole system so that hopefully we can implement these rules. We got 5 months.
What could go wrong? Yep. Supervisor McDevitt.
Trying to better understand the intent of the law. If you were to say, here are the 3 or 4 reasons why the New York State Legislature wrote this law, what was their intent? What was their objective?
I think their number one intent is they believe that if you look at the jail population throughout the state, there's predominantly more unsentenced people than sentenced people in local jails. Their belief is that a lot of people, for the lack of small amounts of money, can't get out of jail. So they believe that they're just sitting there, they can't get out, and they're forced into disposition in jail time. So by not having money be an object for bail, they have the same liberty as everybody else. And I think that's the clear intent. I think that's number one in driving factor behind that.
Good. Anything else for the probation director? If not, thank you, Bob. And thanks for the slideshow. That was very helpful.
Bears of great news, aren't they, today?
Probation. Fire prevention building code. Charles.
Good afternoon. Last fall, when I was asked to come up with a fee schedule over the next couple of years, bring our fees up to increase more income and make them closer to what other fees that are within the county. So I spent some time this spring looking at different fee schedules that the towns are charging for zoning, and was trying to come up with some numbers that are going to get us closer to those fees. So what I included in here was our current fee schedule that we're running right now, an increase for the remainder of this year, and then an increase in 2020. So, certainly have their input on that, and see where we want to go with these new fees. I mean, basically, for the 2020 fee, we're going to increase
Mostly
1,000 square foot house is going to go from a $300 permit plus a CO fee to a $500 permit with a CO fee. 2020.
Supervisor Drift.
Thank you, Mr. Chairman. Thank you for the information, Charles. I just had a question about the need for a new fee for August in the next 5 months. Do you create confusion on the part of the public who may pay a fee in June, maybe another one in September, and then another one in January, and 3 different, fees?
Only to try to ease into such a dramatic fee in January. I mean, the 2020 January fee, that can be implemented at any point in time. It's just trying to get numbers bumped up to where they are, like in kind of what you said.
I have no issue with that.
That was the only reason.
Okay, all right, thanks.
Supervisor Hogan.
I just want to say, I'm sorry. I was supposed to be working with you on this and totally dropped the ball, so thank you for going ahead with it.
Supervisor Wild.
I have to reiterate the same, Supervisor Hogan. I was one, I think, that prompted this, because we're talking about your budget and the lack of revenue to cover the expenses that you have, and I also need to apologize and thank you for going through this. I do have a follow-on question, though, and more to the towns. What are your impressions of this fee schedule, and what's it going to do to your towns?
Well, there we go, Chairman.
Oh, yes, Mr. Simpson.
Chairman, you was looking at me.
Supervisor.
and I
jump the gun. Myself, I think we should look at it differently. Every year there's more and more regulations, more and more responsibility put on the county. It's not our doing. We're going to keep raising the fees, and I heard Charles say that he looked at the town zoning. Well, we looked at the county zoning, so that's, I don't know if we should be doing that. I think we need to look at this, and I don't know how we could ever offset all of the costs of that department and put it on to, I think we need to take a step back, look at this differently. You raise these fees to a certain, we keep raising them, I'm not speaking of you. Towns keep raising, we're pushing ourselves, for, what is involved in that $500 for, notice there's a septic permit, so that's another permit, you're gonna have to get on top of the building permit.
It is. Well, minimums I left alone. So minimum fees for a single-family dwelling in addition to deck porches. I chose not to raise them whatsoever because individuals are paying, in most cases, the zoning fees. Some towns don't charge any zoning fees. They don't have any zoning. So I kind of looked at it across the board from towns that have jurisdiction. So somebody comes in and wants to add a 10 by 12 deck onto their house, they're paying the zoning fee, and then we're doing a $50 minimum fee. We're out there a couple of times, it's probably adequate. I didn't feel there was any room to add to that minimum fee. Where it starts coming into play is when you start getting into square footages, that's where you're going to get above that $50 minimum fee. So it's not going to affect, I didn't touch pools, solid fuel devices, demolition permits, septic permits, any of those things I left totally alone. And it's really just when you start getting into the bigger square footage, we didn't raise fire safety inspections, and that's anything that's probably one of the bigger complaints that we do get, fees for fire safety inspections.
And your reasoning behind that was not to discourage people from getting those inspections, correct?
Absolutely. I believe that in most cases, what research I've done, there are no fees for fire safety. I did propose to raise manufactured homes to $100. On our old schedule, if they were on a permanent foundation, that was the fee. Almost every manufactured home has to go on a permanent foundation now, so just across the board, $100 plus the CO fee. So we're looking at more and more stuff out of single-family homes when it comes to energy. We're there more times than we used to be. So when it got all said and done, 2020, I kind of made them 25 cents a square foot, along with businesses. In some cases, that can be a fairly large amount of money. So again, that's up to the committee to decide where they want to go with all this. I was just trying to trying to get closer to offsetting our costs.
Supervisor Bramer, then Supervisor Simpson.
As I recall, we did ask Charles to look at this and to raise the fees because we were lagging so far behind. Not just our revenue, but in comparables. So I am pleased that you did this, even if maybe we didn't have all the input that we promised you, and I'd be happy to support this.
Supervisor Simpson.
In Horkin, we put a maximum fee. So, the example that was used was a 2,000 square foot house. There's many houses in Queensbury and in Warren County that are way over 2,000 square feet that pay a lot of money for their permits and all these fees, and we just need to be aware that this is significant. You add the town zoning fees on top of this.
Right.
I had an experience with a 10,000 square foot building in Horkin, and it was thousands of dollars. Thousands. And it was a replacement building.
If I may add.
Yes.
With those big buildings, there's a lot of trips there. We currently have, fortunately they're all going at the same time. Word of Life is putting up 3 buildings all at the same time, so we're do 3 different building inspections almost daily that were light. You know, big hotels. I mean, yeah, these fees will dramatically increase the cost of the permits. However, when you factor manpower hours into it, it does not offset the amount of time that actually is spent there.
Supervisor Garrity?
You know, our fees are not that much in the town. You know, I'm not, I wouldn't advocate because you do most of the work. We don't expect it, and they're doing the work, so I'm appreciative of the county, and if it takes a little more I mean, building codes in 2006 and building codes in 2019 is 9-day difference. You know, and we don't get a lot of complaints. That used to be one of our biggest complaints, was people getting building codes. You're doing most of the work for our community, so you know you need to get paid for it. Your trips. I mean, I don't like raising fees on anybody, but guess what? Everybody wants to raise and pay, so you got to collect this somehow. And our fees are, we keep ours at bare minimum in town because they're doing the work. We're not out there doing the work. You know, and then when they put the permits on for asbestos and all that, it's just another thing. I support you, Charlie.
Supervisor Wild, then Supervisor Sokol.
Mr. Chairman, thank you. Just a brief comment. This is a New York State mandated activity. It's a New York State building code, right? So it's not something that the county's doing or the towns are doing. We need to recognize that. And I think it's important for us to try to recover some of our costs, maybe not all of it, because we still want to support businesses and we do want to support people going through these inspections for their safety. So I'm in support of this, even though I wish we weren't going as far, but let's do what we need to do.
I'm open to having the committee decide where they want these numbers to be set at. I mean, I just coming back with some suggestions based on what kind of things raised.
Supervisor Sokol first. Supervisor Sokol first.
Thank you, Mr. Chairman. It is a 50% jump, but, I mean, if it's in line with other, I mean, did you do comparables? Are we, okay. I would make a motion that we approve this, if that's what you're looking for.
I would second that.
Would you? Okay.
But I
So,
do
yes,
have a
and
follow-up,
now
Mr.
a
Chair,
follow-up.
if you don't
We have a first and a second to adopt the fee schedules as presented by building codes. And now discussion on that. Supervisor Wild and Supervisor Hogan.
And Charles, just a brief understanding. We were running a deficit before of what percentage, and what percentage are we now? We're still going to be running a deficit based on your costs, right?
We are, definitely. We needed to raise 168% to offset to become zero.
And how much did we raise it? We're raising it
Well,
15%, 20%?
That number's going to be very difficult to come up with because so many items here are not changing, and some additions are not going to fall, or are going to hit that above $50. You know, decks, there's a lot of items that we're going to issue permits on are actually not going to change whatsoever. It's only when you start getting hit in square footage sizes that are above the $50. So that coming up with that actual number, I can't pull that out of our IT, our database, to say how many of those, what that number's going to be. I'm suspecting somewhere 20 to 25,000, but I'm not 100% sure.
And to put this into perspective, a $200,000 house at the county's tax rate of $297 is going to be about $794 more in tax revenue a year as well from here into perpetuity. So there's, you know, when you're dealing with buildings, to recoup all of the costs of that building codes does, there's ripple effects through to the county obtaining more tax revenue to help supply some of that. So Supervisor Hogan.
Was the motion to accept the phased or just?
You know, as presented here, the numbers and the phase.
I don't think I'm in support of the phased approach.
What would be your consideration?
They just change it to this as of January 20.
Which one, Andrew?
The
So Charles gave us, as of August, these will be the fees, and then January, these would be the fees.
Yes.
Want to go with January?
Just the January, yeah. Maybe we'll see a building boom between now and January.
So, we're doing pretty well now. Who made that motion?
I did, that's fine. If that's the wishes of the committee, I'm okay with that.
Yep, yep. Committee, you good with just taking the one big jump starting in January? Okay. Supervisor Wild, you had the second on that. You willing to amend?
Absolutely.
Okay. Supervisor Bramer, then Supervisor Driscoll. Supervisor Bramer? Did you have a
I just
question?
wanted to clarify, so the motion is to implement the January 2020 fees in January of 2020,
That's correct.
and skip the, okay, thank you.
All right.
I support that too.
Okay, Supervisor Driscoll, did you have a
No,
question?
no, I support that also.
All right, any further discussion then? Call the question, all those in favor?
Aye.
Opposed?
Opposed?
One opposition, thank you. Motion carries.
The only other thing I have is a request for committee and a resolution to allow for Tom McKinney to attend the 2019 conference in Las Vegas at no cost to the county. It's covered by Firemen's Association
Okay.
of New York.
Okay, we have it brought to the floor by Supervisor Sokol, seconded by Supervisor Bramer. Any other discussion? Is there anything else you'd like to add to that? Looked like pretty straightforward, so, okay. All those in favor?
Aye.
Opposed? None? Motion carries. Thank you, Charles.
Thanks,
Public Defender Flores?
Thank you. I only have one item. I would like to attend a conference for myself to attend. Originally, I wanted to go to the one in Austin. It's already sold out, so that leads me to the December one, which is in L.A. My concern is by the time the full board votes, I could be locked out of the one in L.A. I have tried to find out what they're going to do next year. They have not posted anything. It's the National Defenders Association. So I would like permission to attend the one in L.A. or in the alternative, if I'm locked out, is it possible to say that in the future that I can go to one next year? And all the funds are being covered by ILS. The county doesn't pay a penny.
Well, we have a motion by Supervisor Bramer, seconded by Supervisor Garrity. All those in favor?
Aye.
Opposed?
That's it.
And any comments on bail reform or discovery?
No, I think you've heard enough today. and you
Okay.
will- It's been a long day.
Thank you, Morris.
Thank you very much, everyone.
Privilege of
Thank
the
you,
floor?
Mark.
Hearing none, adjourn the meeting.
I disagree. I don't think